Hampshire Municipal Association is going through some restructuring. As a result of that process last year, this past fall, the law lectures that have been hosted around the state at typically 8 or 9 different locations were condensed, and the number of venues was reduced. And the Lakes region lost Meredith is one of those sites. Since I started at the Lakes Region Planning Commission in 2000, this has always been an annual event where people migrate, and a great opportunity to learn. And with the absence of a law lecture this past fall in Meredith, the Planning Commission has always been engaged in helping host the law lectures. We decided that we would reach out to some practicing area attorneys to see if there would be interest in them joining us and making a presentation to folks in the Lakes region that are interested. And so thanks to the Lakes Region Planning Commission for hosting, the Bean Center for allowing us to use their facilities, and to Bernie Waugh, our first guest speaker, and Daniel Crean for presenting some information that they customized for the meeting tonight. You should have picked up a packet when you walked in. The packet contains 3 different handouts, the first of which is Bernie Waugh's notes associated with his presentation, and then the second is Dan's PowerPoint presentation that he's going to make, as well as his background notes for that. There's extra copies at the end of the program. If you're interested in taking a couple copies back for other members of your planning or zoning board of adjustment, you're welcome to do that. We'll have them on the table. At 8 o'clock, we're going to have a brief intermission. You may have noticed when you came in, some ice water and juice, some fruit and cookies. Help yourself to those items. The bathrooms are right outside of this room on the left if you need to use the facilities. Other than that, I hope everybody's comfortable and ready to absorb what our attorneys have to say.
Good evening, I'm Bernie Waugh. I'm going to go first here. I have this one that says Summer 2014 Law Update for Land Use Officials. How many of you are planning board members? How many of you are zoning board members? And other? Well, how about Conservation Commission? Yeah, a couple. This is divided into, statutory changes from the last 3 or 4 years, and then also some important case law. I'm certainly not going to get through the whole thing. I'm just going to hit the highlights. Common wisdom is that you start with a joke, so I will do my best. My younger brother is a viola player, and there's all kinds of viola jokes around. But one of them that actually involves a lawyer is, how is a viola player like a lawsuit? Everyone's happiest when the case is closed. I've started on the first page with, I'm not very high tech, so feel free to look at this stuff, but my stuff is in the paper. I've started with a 2009 change. For those of you who are on zoning boards, I'm sure you know that there is now a statutory definition of unnecessary hardship, which is the one of the main, I would say the main criterion for someone who wants a zoning variance. And I only mention this because since this law passed, I've noticed what I think of as 2 main mistakes that boards have been making. And the first one is just because the unnecessary hardship criterion is last, they tend to treat it as being last. And it really should be treated as being first. In fact, what I've noticed is your applicant usually comes in and they will have a huge presentation on the other 4 criteria, and then they will have a very short presentation on unnecessary hardship as if you meet the other criteria, you somehow automatically meet unnecessary hardship. Wrong. That is not the way it works. I would recommend that you look at, as a board, look at unnecessary hardship first, because it still is true that 90% of the cases that are litigated turn on that, and the other 4 criteria are more of a check. The other mistake I've noticed people making, and I've put down what the definition of unnecessary hardship at the end of the page 1 there, is that they give a little bit of short shrift to the last standard, which is the proposed use is a reasonable one. In fact, I think some people think that's sort of an invitation for board members to exercise their own purely subjective judgment about what is reasonable. In fact, I've even seen board members talk about, well, is this regulation even reasonable? I don't think that's the right approach. You've got to assume the regulation is reasonable. After all, it was enacted by your local governing body, local legislative body. And the thing that you need to notice is that the phrase owing to special conditions of the property that distinguish it from other properties in the area modifies both of the standards underneath there. So the reasonableness of the use has to result from the special conditions of the property. And that should not be forgotten. In fact, I think it's reasonable to think of it as you assume that the use is unreasonable in general because it violates the ordinance. Is there something about the special conditions that makes it reasonable? I think that's the better way to think of it. By the way, feel free to break in, but I would ask that you not tell war stories. If I'm saying something you don't understand, break in, but if you want to ask for an example or something like that, jot it down on the back of your we are going to have a Q&A session at the end. So, and I think we both have quite a bit to cover. The next one on page 2 is 2011 statute that says planning boards can't regulate timber harvesting. The only caution I have on that one is that this is talking about planning boards. It does not prohibit zoning ordinances from regulating timber harvesting. The statute that covers that is the subparagraphs of the introductory provisions to the planning and zoning laws 672.1, Roman 3D, and 3E. And basically you can regulate timber harvesting as long as it is not unreasonable. So it's not a complete prohibition on that. Another 2011 statute at the bottom of page 2 is the one which was a follow-up to the previous law, which said you couldn't have a zoning ordinance that required lots to be merged. And then this law, this 2011 law, said if you've had a town require you to merge lots, you now have until December 2016 to apply to the selectmen, why not the planning board, I don't know, but to the selectmen to unmerge those lots. We're going to talk about a couple of cases where the Supreme Court of New Hampshire has talked about what it takes to, because you can apply to the selectmen to unmerge lots if you have voluntarily merged the lots in the past. And what does that mean? Well, there's a couple of cases on that. Yes, sir.
Yeah, on your timber one, is that going to include cordwood? What's going to happen with that, the way that rates are getting cut?
Well, there's no state law on it at all. I mean, there is. There's the so-called basal area law, but that will hinge entirely on what the town decides to do in its zoning ordinance.
And then the next one, I happen to be mixed up in a deal on that. I sold a gravel pit, and when me and my wife sold it, it was 2 different pieces. It was a front property and a gravel pit. And after it got sold, it got merged, and then the people...
Merged by who?
Well, that's what we can't figure out. They say that the town, Attorney Wood said that the town merged them. But then we went back to the tax collector, and now they're kind of like jiving back and forth because they're worried about the reclamation on the pit. They don't want to unmerge it. But
well, why don't you wait until we get to those 2 cases, because the court has given some sort of guidance on that. on that issue. I hate to put people off like that, but I am going to get to that. The next one on page 3 was a 2011 change to the so-called 4-year exemption, which you probably know is now a 5-year exemption. What does this mean? It means that if you have a recorded plan approved by the planning board, it may be, or it will be, exempt from changes in regulations for a 5-year period, as long as at some point before the end of the 5-year period there is substantial completion of the improvements. And also there's an advance loophole that threshold that also has to be met, but only, which is now I keep forgetting the phrase here. Active and substantial development. But that threshold doesn't apply anymore unless the planning board actually specifies, either in its regulations or in the specific decision, what will constitute active and substantial development. So it's basically the so-called 4-year exemption has been changed in 2011 to a 5-year exemption. There's also a case on that that I'm going to talk about a little later. The next one I'll skip. The one on the top of page 4 is a 2012 statute which says that Conservation Commission members can't enter private property without permission. Now, I had 2 comments on that one. I mean, what if it's a piece of property that's already open to the public by virtue of a conservation easement or something? This bill almost seems to say that Conservation Commission members have less rights to enter private property than regular members of the public, at least in some cases. But I don't mean to make light of this. I think if you are on any land use board, you should pay very close attention to the question of whether you have the legal right to enter property. If you read certain statutes, you might believe that you have the right to enter somebody's property without permission. Don't believe it.
I just went to a seminar not too long ago because I'm a designer and an installer and septic, and I also work on wetlands. And they told us at that seminar, this was last year, that if it had, like in Bow, that one aquatic area that's in Bow there by the fire station, that if you have to go through, you can go through somebody's property to get to that.
Well,
It's a beaver pond or something.
what I'd like to say is that my sort of a general rule of thumb, if you are acting on behalf of a governmental entity, if you're acting in your role as a planning board or zoning board member or whatever, Conservation Commission, always ask permission. And if you don't get permission, then you might be able to get an administrative inspection warrant. But alternatively, if you're on a board member, if you're a board member of a board where somebody is asking permission from the board, you can cover this issue in your application procedures. You get to the hearing stage and you say, well, we're going to have to come out and take a look at your property. You don't mind that, do you? And if they say yes, then you say, well, gee, how are we going to get the information we need to decide the case? I mean, a site visit is worth thousands of words. So I think you can cover it that way if you're actually on a review board. But again, there are cases throughout the country where people have entered onto private property as government officials and gotten caught with a Section 1983 lawsuit against them for violation of constitutional rights. So it's something you should be fairly careful about. The next one was a 2013 statute that enables planning boards to adopt regulations to protect archaeology. That may not be very interesting to too many people, but at least allows me to review what I consider to be the /1 rule of municipal law in New Hampshire, which is you can't do something unless the legislature says you can. Apparently there was no authority to protect archaeology until this law passed. They didn't define archaeology, by the way, and you see my comment there. Do you suppose it includes those multi-year piles of paper in the back of my car? The next one is another 2013 statute, which is how long does a variance or special exception last, or how long does an applicant have to actually implement it before it expires? And the legislature has said it has to last at least 2 years. You can, in your local regulations, have it last longer than that, but 2 years is a minimum. And furthermore, if you have a case that requires both boards' approval, such as you need a variance and also site plan review, if you file your site plan review application before the end of the 2 years, then your variance or special exception remains good until the planning board's procedure is concluded. So it really is 2 years plus in that kind of case. One question is, what does it take to exercise a variance? What does it take to implement a variance? Do you just have to take a bulldozer onto the property, or, I'm speculating here, but I suspect that it will be considered to be a substantial construction threshold as set forth in some cases like the AWL Power versus Rochester case that I've cited here. But we don't know yet. The next one on page 5, planning board appeals to the zoning board. There are very few planning board decisions that can be appealed to the zoning board, but if the planning board makes a decision in the course of site plan or subdivision review which interprets or applies a term in the zoning ordinance to the project, that aspect, and only that aspect of the planning board decision, can be appealed to the zoning board of adjustment. And this has resulted in some strange things, because some planning board decisions, because they have this aspect of interpreting the zoning ordinance, that part has to be appealed to the zoning board, the rest has to be appealed to the Superior Court, and people have lost their rights because they didn't know which way to go. This was intended to remove the tracks for the unwary, because basically it says that if you file in court and you should have gone to the zoning board, that's okay. The court will send it to the zoning board, or vice versa. You won't be held to have not met the timing if you do meet the timing of one of those routes of appeals. But again, I think it's very important that this is only a very limited class of decisions. If you are talking about a type of authority that the zoning ordinance specifically gives to the planning board, which is not the same as subdivision or site plan review authority, that can't be appealed to the zoning board. That is something that the planning board is a discretionary type decision, which can only be appealed to the Superior Court. I know there's a couple of towns that I work with in the northern part of the state where virtually everything goes to the planning board. In Whitefield and in Colebrook, for example, and I thought that none of those types of decisions would be appealed to those towns' zoning boards of adjustment. The one on page 6, at the middle of page 6, I'm skipping sprinklers for now, is a very important new as of 2013 statute which preempts local authority to regulate telecommunications facilities. You may know that we've had preemption to some degree from the federal government under the 1996 Federal Telecommunications Act, but for the most part, local authority to review those projects has remained as long as you don't exercise that authority in such a way as to preclude coverage. This is, I think, a state type of preemption, which is fairly broad. If somebody's going to put in a new tower, then you have the same authority you've always had. But if it's going to be co-location, then you don't review it at all. I mean, they can just do it. And obviously the intent of this is to encourage co-location. But the surprising thing is how broadly co-location is defined in this new statute.
Croc TV.